Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So today we're going to talk about a case out of Oklahoma where the good guy lost, then won, then lost again, then won. It's a wild one. I'll be with you in just a sec. Because I'm not really clear on how the win-lose thing went, I wanted to sort of put this in a timeline. This involves a foreclosure judgment and then a motion to vacate, which was denied, so the first loss. It was reversed on appeal, so that's the first win. The gentleman filed a malicious prosecution suit, which was dismissed. That's another loss. The Court of Appeals affirmed the dismissal. That's another loss. And then it goes to the Supreme Court, and the Supreme Court reverses. So it's not every day that you see interesting opinions coming out of the state of Oklahoma, but every now and again one will come through that is really worth the time to sit and enjoy. Now, there are two parties in this case, a gentleman by the name of Mr. Cole and the Bank of America. Now, I am no fan of the Bank of America. We have had some difficulties with them getting credit card issues straight in the past. And so I have a bias against them. I will be free to admit that. But this case is interesting for a number of very important reasons. One, most important to me, is the legal ethics involved, and also a rather novel cause of action that you don't see every day in the courts called malicious prosecution. So let's get started. In this case, Mr. Cole was sued by the Bank of America in a foreclosure action. Here's how the synopsis written by the state Supreme Court starts. Former homeowner against whom foreclosure action was dismissed after he had succeeded on appeal brought suit against bank, his former adversary, and its attorneys for malicious prosecution. The judge dismissed the claims for malicious prosecution and the former homeowner appealed. The Court of Appeals affirmed, and the certiorari was granted for the single issue before us is whether the original action was terminated in appellant's favor. We hold that it was. But how they get there is something that's really worth a closer look. So I think the best place to go in this situation is directly to the opinion. So here's what the opinion says about the underlying facts and how all this came about. Mr. Cole, after a favorable appellate ruling vacating the judgment against him, filed this action, including claims for malicious prosecution against the Bank of America and its legal counsel. And Cole alleged that the bank and its attorneys acted with malice and without probable cause when they filed a foreclosure action against him and obtained judgment for a loan modification agreement defendants knew he had not signed. The details of this prior foreclosure action or original action will be discussed later. So, the long and short of it is this. There was a note that was signed by both husband and wife when they were married, and then there was a divorce action where the wife was awarded all of the financial responsibility and the home in the divorce action. Now, this is fairly common. You'll often see a situation where marital assets are divided, and normally there is an order to the parties to take the steps necessary to get the non-obligated party, in this case Mr. Cole, off of the underlying note. But for whatever reason in this case, it doesn't appear that that's what happened. Nevertheless, apparently Mrs. Cole fell under some hard times and sought a loan modification agreement from Bank of America. Now, Bank of America had to know that there was a loan modification agreement because that was the basis for the interest rate that they were going to charge in this foreclosure action. So they had to know that it was there. But I think what they looked at was they looked at the fact that maybe Mr. Cole had more assets than the wife did. And so they went after Mr. Cole as well because he hadn't been taken off of the note. Now, this is a point that I think I want to make for people who may have to go through a divorce either in the future or who might be going through one now. If you are obligated on a note with your spouse, whether it's on a car or a house or a boat or anything, you want to insist that your lawyer get you off that note. Now, usually that's just a matter of going to the bank and saying, I want off of this. And normally there are a couple of ways that banks can work with you to get you off of the note. In this action, we're going to go back to the opinion now. Cole alleged that not only was the prior foreclosure action spurious, but the bank intentionally or recklessly hid the fact of a subsequent loan modification by Cole's former wife until judgment was obtained against him. That's right. If you look at the timeline, Cole pointed out that bank and its attorneys repeatedly misled him as well as the trial court to believe there was only a single operative note. Cole stated that he prevailed on appeal and the trial court was directed to vacate the judgment against him. On the same day the trial court vacated the judgment, the bank filed a dismissal without prejudice, stating that the defendant was not being a necessary party herein, and claimed that Cole then claimed he was entitled to recover compensatory damages to include attorney's fees, time missed from work, damage to his credit score, as well as emotional distress and punitive damages. So the bank, as you might imagine, filed motions to dismiss, saying, no, this wasn't a situation where an action was terminated in his favor, which sort of flies in the face of this. They're claiming that because they dismissed him after the appellate court ruled that it wasn't a termination in his favor, but very clearly it was. The defendants argued that under Glasgow, which was a case that was decided prior to this one, that a dismissal without prejudice was not a termination that favored the party. Defendants did not deny Cole prevailed on appeal, or that the Court of Civil Appeals described the judgment against Cole as inherently defective. Nevertheless, the trial court granted the defendant's motion to dismiss the malicious prosecution action, and so Cole appealed. So it went up to the Civil Court of Appeals in Oklahoma, and the Civil Court of Appeals said, no, it wasn't terminated right. It wasn't terminated in your favor. Sorry, you lose on the malicious prosecution. Well, Mr. Cole wasn't going to let go of this, so he sought certiorari, and the certiorari was sought on the sole question of whether he had prevailed on the merits in the underlying claim. And the Supreme Court took a look at the original foreclosure action next. Here's what it said. Next, we examine the details of the original foreclosure action. Almost 2 years after Cole and his former wife divorced, she solely executed the loan modification agreement with the bank on the house the couple had previously purchased during marriage. Pursuant to the former couple's divorce decree, former wife was awarded this house altogether with financial obligations. Prior to judgment against Cole, the modified note and its details were never disclosed to Cole or to the trial court. Bank and attorneys mentioned only a single operative note and provided only a copy of the original note, which had been executed by Cole. So reading down a little further, Cole also argued there were additional irregularities, casting further doubt on the authenticity of the bank's evidence. More than 2 weeks after the motion was filed, attorneys for the first time revealed to Cole's counsel there was a loan modification which Cole did not sign. 3 months after the motion was filed, the bank for the first time provided a copy of the loan modification to the trial court. Although bank admitted that Cole had not signed this newly produced note, it argued there was no basis to vacate the judgment. In fact, the bank suggested that somehow its own failure to disclose its modified note was actually the fault of Cole for failing to conduct discovery. Bank maintained that Cole was a proper party to this action and properly named and served, and it disputed that Cole could be harmed in any way by its actions. In fact, Bank boasted that plaintiff had gone above and beyond what is legally obligated in order to resolve the issues amicably without incurring additional attorney's fees and costs. Bank resisted all efforts of Cole to vacate the judgment. The bank continued to argue that Cole was liable under the original note in spite of the fact that its actual note it sought to foreclose on was the modified note. This specific legal issue was never at issue in any legal proceeding, and it is undisputed that the bank was seeking to foreclose the modified note. The district court denied the motion to vacate. Cole appealed, and the Civil Court of Appeals reversed the judgment and directed the trial court to grant Cole's motion to vacate the judgment. The appellate court also noted that under Gross versus Trinity, when a note is signed by a single party, it's materially altered by a change in the interest rate, the note is extinguished. So under either set of circumstances, Cole would have been off of this note. Going on, the court says, the court highlighted that even if the copy had been certified, it was admittedly not a copy of the note that was sued on. So when they submitted this note to the court, they didn't verify it. And there's a reason why they didn't verify it, because it wasn't the actual note. That means that it's at least inferable that the attorneys knew they were trying to get him on a note that he had not signed. And there are very few things that can screw up a lawyer's career more than putting false evidence in front of a court. And yet, it appears that's exactly what they did. Now, I'm not sure that's what happened. We'll have to wait and see how this plays out at trial. But certainly in the evidence that is in this appellate opinion, it looks to me like perhaps the attorneys made some huge ethical missteps here. Now, what would have been the proper thing to do when they discovered this other note, this modified note? It would have been to immediately move to dismiss Cole and pull him out of this lawsuit. If they had done that, there wouldn't have been a motion, there wouldn't have been a malicious prosecution action, because they would have done the right thing. And neither the bank nor the attorneys would be liable on a malicious prosecution claim. But now you have the possibility of them being liable on this malicious prosecution claim because they put false evidence in front of the court, and they had to have done so knowingly. So the trial court vacated the judgment against Cole on remand after the Civil Court of Appeals said, the judgment is inherently defective. The trial court vacated the judgment on remand the same day the bank filed a dismissal without prejudice, saying the defendant was not a necessary party. So the bank went on to obtain a judgment against the former wife, and now the court takes a look at the malicious prosecution action. And it's important at this point to point out what the elements of a malicious prosecution action are. The plaintiff in a malicious prosecution action has the burden of affirmatively proving 5 elements: the bringing of the original action by the defendant, its successful termination and plaintiff's failure, want of probable cause, malice, and damages. And I think we've got all of that here in spades. So one of the 5 elements the plaintiff has to prove is this successful termination. And the court says we apply a case-by-case determination as to whether the dismissal in the original action is a successful determination and shows the plaintiff to be without fault. Here it was pretty clear that he was without fault. He kept saying this can't be true. I'm not liable on this note. The interest rate is different, and this is not the note that I signed, and all these things. And yet, in spite of that, the bank and the attorneys continued to press forward. So there was one case that had been decided where an entire action had been dismissed without prejudice, and that was before any appellate ruling. And in that case, the court decided, hey, look, a dismissal without prejudice, that is not a successful termination in your favor. And so, as a result of that, the Civil Court of Appeals said, well, I think this is not a good malicious prosecution case, and they affirmed the dismissal of the trial court. So, as was his right, Mr. Cole took this up to the Oklahoma Supreme Court and the Oklahoma Supreme Court was asked to decide one question: was this a successful termination? And they decided yes, it was. Here's what they said: ESCO does not support the conclusion urged by bank and attorneys that a dismissal without prejudice is never a successful termination of a prior action in the context of a malicious prosecution claim. This surface analysis is legally flawed. It ignores the critical differences in the matter before us. There was no dismissal of an action on procedural grounds. There was a determination on the merits by an appellate court as to the sufficiency of the evidence to support the foreclosure judgment, and Cole was vindicated on appeal as the judgment against him was vacated. Further, Cole's dismissal as a party in the subsequent amended petition effectively extinguished the claim against Cole as to the loan modification foreclosure action. At the time the dismissal was filed, Bank knew that Cole could not be liable for a subsequent loan modification he did not authorize, and the only evidence produced established that Cole never signed or authorized the modification. So in conclusion, the court said this: we find Cole's dismissal in the prior foreclosure action was based on a decision on the merits, and as a result, they reversed the Court of Appeals and they reversed the trial court, and they sent this back to the trial court for discovery and trial. Now, there will be discovery and trial. There will be, because the lawyers have been sued along with the bank, there is a situation where the lawyers are now adverse to the bank. So the lawyers that represented him in this action to begin with are unlikely and probably cannot represent them in this section because there's a conflict of interest. Because the bank can throw the lawyers under the bus, and the lawyers can throw the bank under the bus. The lawyers can throw the bank under the bus by saying, hey, we never knew, they never gave us this modified note. And the bank can come in and say, hey, the lawyers screwed this up, we gave them the modified note on day one. It's just a question of what the facts really are here. And it's difficult to know, but this is a really wonderful situation for the plaintiff, because anytime you've got the bank pointing at the lawyers and the lawyers pointing back at the bank, well, it's like this. Anytime you're pointing with this finger, you got three fingers pointing right back at you. It just makes you look guilty. And so there's a good chance that Mr. Cole will prevail on this malicious prosecution action. And I really champion the lawyers here who pursued this on his behalf to the Oklahoma Supreme Court, because it's a good ruling. And it's a affirming ruling in terms of, lawyers are supposed to do the right thing. And when you know there's a screw up or that somebody has done the wrong thing, you have to stop. You can't put false evidence in front of a court. You have to correct the record. You can't leave false evidence in the record and expect to prevail. I would be absolutely amazed if there was not a disciplinary action brought on behalf of, or I shouldn't say on behalf of the lawyers. I would be amazed if the lawyers were not subject to a disciplinary action here, simply because they put false evidence in front of a court. There is something called candor to the tribunal. That's a rule of professional conduct, and it says you can't put false evidence in front of a court knowingly. Now, you can't stop your client from lying if you don't know that he's lying. But if you know your client's lying, you can't let him lie. Well, if you're saying that this is the note that you're suing on and it's not the note that you're suing on, it seems to me that there's a problem with being candid to the tribunal here. So we'll see how this shakes out. It'll be an interesting case, and hopefully Mr. Cole will prevail at the end. I think he's entitled to, given the situation that is in this particular case. If you have any questions, leave them in the comments down below, and I'd be interested to know your thoughts on this particular case. Do you think the bank made a mistake here, or do you think the lawyers did? Who do you think probably did the wrong thing here? And what do you think about Mr. Cole's theory of malicious prosecution? Is that something that people should be able to bring when somebody does them a disservice through the court system? Personally, I believe it's the case, but I'd love to hear from you on that. Thanks again for watching. Have a terrific day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.